Assets to protect those are those that you can move outside the United States, especially if you can move them easily, like stocks, bonds, cash, a brokerage account, or crypto. The biggest mistake that people make is waiting too long. An ounce of prevention is worth a pound of the cure, and that is never more true than in the asset protection field. The Swiss banks, I talk about them being safer. The American banks will often have about 5 to 10% of their cash on hand. Swiss banks will often have anywhere from 25 to 40% of their cash on hand.
Mr. Blake, appreciate you hopping straight off an airplane into the studio for us.
Hey, Brian, good to be here.
Yeah.
I like to keep things rolling, like to keep things going, got to keep moving. That's the secret to a long life.
I feel like you're always on a plane.
I'm on a plane quite a bit, but doesn't just part of the job, occupational hazard.
You know, you have...
Am I giving it away?
A doppelganger.
A doppelganger?
Yeah.
Oh, please don't insult me.
No, it's not an insult. It's a really good character.
Okay, all right.
Daniel Stern.
I don't...
Home Alone.
Okay.
Marv.
Oh, okay. Yeah. Well,
take the glasses with I saw you with the glasses off, and I was like, "Oh my God, it's Home Alone."
You could have done better, but you could have done a lot worse too.
Okay,
so,
good.
Okay. It's
so
okay.
We have this thing where, again, he says, we have this guest. I see the name of the guest, and usually I try to figure out just from the name what industry they're in and what they do.
Okay.
And so it all started from a porn star that he said we're going to interview.
Okay.
And he sends over the name Sterling Cooper, and I'm like, man, this chick sounds like a hot chick.
Yeah.
So let me write down a whole bunch of questions about her and like
based on her name.
Yeah.
Okay.
And then get all this, questions asked during the show. So after I write a whole bunch of questions, I go, let me Google her, see how she looks. If she's older, younger, kind of like what types of videos she makes. And it ended up being a dude.
Oh, wow.
And I was like, oh shit. Like I wrote all these questions and it's a dude. So I had to like throw it away.
You were looking at a schlong.
Yeah. And when you Google a porn star, the schlong comes.
Oh, it is a porn star.
Yeah.
It's a male.
But a dude.
Well, right. Yeah. I caught that based on the...
So every episode, I've been just guessing who the guest is.
Okay.
And just based on the name, I was thinking like a pharmacist.
Pharmacist.
Yeah.
Okay.
And so my guess with you is you're in the pharmaceutical space, maybe.
No, not at all. I've actually never sold drugs.
No, like pharmacy drugs.
No, I understand.
Yeah.
I understand what you're saying. No, I don't even take pharmaceuticals myself. So not even close. Porn might have been closer.
Porn would have been closer?
Because I do spend some time on video and moving around, but it's not pharmaceutical, and it's something that I keep my clothes on for.
Okay.
Do you get a second guess, or do we tell you now?
Well, the second guess, based on appearance,
okay.
I would think like psychedelic drugs. not psychedelics, but like you're into ayahuasca and like holistic medicine and holistic.
You are so far off.
I know.
Well,
I know because you guys are
actually personally. And we're going to speak in the hypothetical for
sure
for legal purposes.
And this is being filmed in Mexico, so the jurisdiction is.
But no, I'm very much an advocate of plant-based medicine.
Nice.
And I had an excellent experience with it. I can share at some point.
Me too.
I'm happy to talk about it on camera, but not my line of work.
So tell us about yourself.
Okay. Do I get to say what line of work I'm in now?
Sure,
Okay.
yes.
So I'm an attorney. I thought that you might be able to get that if you guess broadly, but if I'm not dressing like an attorney, that's actually a goal of mine, because when I started in the practice of law about 15 years ago, I would wear a suit and a tie every single day. I didn't know what I was talking about. I had to compensate for it. As I got more comfortable and confident with what I was talking about, I dropped the suit, I dropped the tie, and I found that it disarms clients. The less you are dressed up, the more they are willing to share. Plus, you work harder when I feel like I can just get my work done and don't have to get dressed up for it. So anyways, I am an attorney. And then within that, I have a very unique specialty. I focus exclusively on setting up offshore asset protection trust to keep my clients' property safe from lawsuits and divorce.
Holy cow.
And
I was
with
so
people too. Yes,
so far off.
And oh yes. We can mention that in a moment if you want.
What did you say?
Fucking with people on Instagram, that's all.
Oh, the trolling.
Yes,
Nice.
I thought it was serious for a half a second. I was like, this.
So the troll is only going to make sense if I give a little bit of context. So what we do is we set up trust in offshore jurisdictions. The jurisdiction we use the most right now is the Cook Islands.
Well, can you, before we dive into that, because this is like, we're going to geek out on this for sure.
Okay.
Just start a little bit earlier back. Tell me like your story, where you grew up and how you got into your field.
Sure. So
wait, hold on one second. This is episode 2 though with him.
I know,
but I'm going to tell a different story.
Okay. Yeah.
I mean, it's the stories are consistent, but we're going to highlight different parts and move along that way. Born and raised in Jacksonville, Florida, undergraduate in law school, University of Florida Gators. The
inventors of Gatorade.
Apparently, yes.
And
that is true.
It was called Gatorade.
Correct.
Not Gatorade.
Correct. I will tell you what I do. They don't teach in law school. The only time I ever remember hearing anything about an offshore trust was when my professor said he would never set up an offshore trust. Went by and saw him after class and said, well, why not? And he said, well, I wouldn't unless these certain criteria are met. And so my thought was, well, none of my law school classmates are going to go after this area. And so it sparked an interest of mine early. And then after finishing law school, moved out to Denver, Colorado, started my law firm there. My office was located just a few blocks away from another attorney's office named Barry Engel. Barry was the attorney who, in conjunction with an attorney out of the Cook Islands, co-drafted the initial Cook Islands Trust asset protection legislation. And for many years before he passed away, he was a mentor of mine. He taught me a lot about the business. And then as I started to get clients on my own, initially I'd partner with other attorneys in setting up the offshore structures. But as I got farther into my career, I began traveling. And I've been to almost 50 different countries, met with trust companies, protectors, attorneys, bankers, and have developed what I'm very confident is the largest Rolodex of anybody in the offshore industry. And so that's kind of how I got to where I am.
Was the travels for personal reasons or for business?
For business. I mean, I'm not going to say that I didn't enjoy a lot of it or occasionally take side adventures, but it was overwhelmingly for business.
To strengthening the protection.
To learn. You will gain more information from meeting somebody in person than you ever will through a Zoom call, through an email. I'm a big fan of the internet. I make a lot of videos. My team is virtual. However, I'm a big fan of the in-person meeting. So getting there, meeting with people in person, it was about learning. It was about building better relationships based on deeper trust. The number one question I get asked is, how do I trust this foreign trustee? When I can say I just traveled with the trustee for a few weeks earlier this year in New Zealand. We went bungee jumping together. We know each other very well. It helps to bestow confidence upon our clients.
Why is it important to know a trustee so well?
Because they're the ones who have legal title to your assets. They're the ones who legally have the ability to decide when you get your money back. Now, in practice, they're very well incentivized to give money back anytime we or the client asks for it. But the way it's set up, we don't want the client to have the ability to directly take the funds themselves. Otherwise, a court can order the clients to hand over the assets.
So online, you hear a lot of these bozos talking about asset protection. There's a poor man's asset protection. There's like all sorts of asset protection. Number one, what should your net worth be before you even think about asset protection?
Well, I mean, before you think about asset protection, it could be very little as a few $100,000. You could start thinking, well, maybe I should put more into my retirement account, which is generally protected. Maybe I could buy a home. And
why is the retirement account protected?
That's the law under state and federal law. There's states that give a certain amount of protection to your retirement account. The ideal being that the state does not want to be responsible for paying for people in their retirement. And if people's retirement is protected, the state has less of a burden. There's a limitation on how much is protected depending on what state you're in. Some states give complete protections for a 401k. That's pretty common. And then the level of protection you get for an IRA varies by state. In general, the first million is going to be pretty well protected.
Across the U.S.?
Across the U.S., it's pretty rare that the first million is not going to be protected.
So first million is generally, if it's in a ERISA type of an account.
If it's in a qualified retirement plan. The exceptions being super creditors, which are divorcing spouses in the federal government. Back to your question from just a second ago, how much net worth does someone need to have for asset protection? It could be a few $100,000, even $100,000. You could start looking at ways to hold your assets where it's harder to collect. In terms of offshore asset protection, where my firm would get involved, generally a net worth about $1 to $2 million. Most of our clients, though, are not super wealthy. Most have not more than $10 or $20 million. So just to simplify it, I'd say most clients have between about $1 and $10 million in assets. Now, we do have quite a few clients whose net worth is a little bit under 1 million. And we do have a few clients whose net worth is significantly higher than 10 million, but there's simply just a lot more people with $5 million than there are $50 million to protect.
Is there a different technique for the 10 million plus that you've seen for asset protection versus the 1 through 10?
So yes and no. It's still a very similar structure in that we will set up a trust registered either in the Cook Islands, Nevis, or Belize, and then we'll open a bank account typically in Switzerland or Liechtenstein. The difference comes in, well, number one, the number of trusts we use. If a client's net worth gets to be around $50 million, that's where we may suggest having multiple trusts in multiple locations. But under $25, $50 million, generally one trust is going to be more than enough. The other consideration is the type of assets. If somebody has just $50 million in cash or a brokerage account or crypto, it's pretty easy to set that up. If you have a more complex structure, we've got real estate in several different countries, businesses, people may owe you some money on top of cash, stocks, bonds, gold, art, then that becomes a more complex plan. The best assets to protect those are those that you can move outside the United States, especially if you can move them easily, like stocks, bonds, cash, a brokerage account, or crypto. Real estate, if you want to put that in the trust, that can be done, but it needs to generally be done in conjunction with an equity stripping strategy where you pull out the equity from the property by either selling it or mortgaging it. But it's the most important part we remind clients is getting the asset into the trust. That way you have flexibility to take further protective measures later.
Are these revocable or irrevocable trusts?
So this trusts are irrevocable because otherwise a court would order the client to revoke it and pay their debts. However, we structured in such a way that it has all the flexibility and all the benefits of a revocable trust. You can add and remove property. You can amend the trust can be dissolved. It has all the flexibility and benefits of a revocable trust, but technically it is irrevocable.
What does it cost to maintain the annual cost for like the trustee fees and so forth?
So generally,
for a typical 1 to 10 million net worth clientele that needs the asset protection,
all in generally $5,000 to $10,000 a year, and that's going to comprise of several different factors. It's going to cover the trustee fee, which may be about $3,000 to $5,000. It's going to cover the fee for the protector, who's a third party that has the ability to change the trustee if we want to move the location or just simply change which trustee any particular jurisdiction is serving. It covers the annual fee for the law firm. The way my firm does it is we bill a flat annual fee. Clients can contact us anytime they want. They're not worried about getting billed. And then it also can cover the annual IRS reporting requirements. If you have an offshore trust, you do have to report it to the IRS and FinCEN, complete an FBAR and some other forms. We provide our clients a detailed memorandum on how to complete the reporting requirements. And as long as the clients follow those reporting requirements, there's no issues. It does not increase the chance of an audit. And it's part of the
Can the IRS pierce it and get your assets?
So we will not set up a trust if a client's intention is to use it to protect against any agency of the federal government. Now, in the past, when individuals have set up Cook Islands Trust, and they properly did this before any issues arose, and later the federal government tried to break into it, the government was met with a lot of resistance. And ultimately what ends up happening in pretty much all situations is the case settles. And the more leverage you can give a client to negotiate, the better.
So I got a question right now. I guess like the initial most commercial I have a commercial real estate background. So a lot of the commercial real estate clients that I used to work with they keep every single property in a separate LLC.
Mm-hmm.
And if you add up the fees in California, for example, there's a minimum $800 tax. Plus, if your revenue is over $100,000 a year, there's additional tax and fees that get added to it. So if you have 10 properties and 10 separate LLCs, you're spending $8,000 automatically, plus all the accounting fees to do the bookkeeping and to filing of the taxes. It ends up being like $15,000, $20,000 just to do that annually. Is it better to create a offshore trust like you're recommending and putting them all in one LLC so that you save all the fees for the LLCs and the operating and the taxes for that?
So first of all, everything you said is absolutely correct. Having a separate LLC for every single property does segregate the liability. And if one asset comes under attack, it's less likely to affect another asset. However, each additional LLC is a headache. It's additional books you have to keep. It's additional paperwork you have to follow with the state. So what we advise for our clients is to do some type of balancing act. If clients have property in maybe 10 properties across 3 states, we may say form 3 LLCs, one for each state where you have property. If a client has each property and they're only worth $200,000-$300,000, we may say wait until you get $1 million, $2 million worth of equity
and put them in one.
and combine those. So it's a balancing act. On top of that, the LLC should have insurance as well, and then
including umbrella,
umbrella insurance for sure, and then back that entire structure by the offshore trust. So have the LLC, the manager can remain the client or somebody local here in the United States, and the member, instead of being the client, would be the offshore trust.
Got it. So you have like maybe make it a GPLP structure is what you're saying? Like
you can do a C corp, you can do a limited partnership or a general partnership, you can do an LLC, which is what's most commonly used. The only structure that pretty much cannot go into a trust is an S corp.
Got it. But if you have an LLC with 2 members, or do you need 2 members for the LLC for the offshore trust, or can you just have a single member? Disregarded.
It's pretty common to have single member.
Got it. So and I've known this as well, if you have the LLC in your name, if you're the only member of the LLC and you take that name out and you have a tenant in the property, just because you took the property out of the title out of the property, you can still get sued. Like for example, let's say you buy a house in your name, and then a month later you put it in an LLC. That tenant can still sue you personally because there was a chain of title where you were still the owner, a previous chain of title.
Well, it's not so much the chain of title. It's at the time that the tenant contracted with you, it was in your name personally.
Yeah,
and
even though you put it in LLC now,
correct, it doesn't do anything until the lease terminates, and then when you sign a new lease, you don't sign with you and the tenant, you sign with the LLC and the tenant.
Got it. So if you do that, let's say you're in a situation where you did take property out of your name and you were in you didn't renew the lease with a tenant and you put it in a trust, foreign trust, does that protect you?
Well, you want to have the property still in the LLC. Mm-hmm. If it's a primary home, we may keep it out of the trust. We may put it directly into the trust. But if it's not a primary home, it should pretty much always be owned by an LLC or another corporation first. That way, if there's an issue with the property, it doesn't bubble up and affect the rest of the trust assets. Mm-hmm. I'm not sure if I got right to your question.
You did.
Okay.
Yeah, you did. Got it. And then what clients would you recommend? What industries do you see that could benefit from these trusts?
There was a time when it was very much for medical professionals. Doctors were the ones who were concerned about it. Their premiums were getting out of control and they were being sued a lot. That's changed. It is a very diverse group of people who we work with. We work with doctors for sure, attorneys, engineers. We work with people in the entertainment business, social media people in media, especially in some political form, are worried about being sued and found liable by a jury who disagrees with their political views as opposed to the underlying merits of the case. People who are in marriages that they're concerned about which direction they're going. People who've made some money in crypto. It's a big variety of people that we see, that we work with. A lot of business owners. That's probably what I'd say is the most common trait, that people own a business somewhere in there.
For the guys, so your client base is 1 to 10 million. For the guys that are $1 to 1 million, what's a poor man's technique that you would recommend for asset protection?
Well, I don't know if I love this saying, but I'm going to repeat it. It's put your house in your wife's name and then keep your wife in your house. Transfer the liability to somebody who's less likely to get sued. Retirement accounts, insurance, annuities are protected up to a certain degree. Gifting assets, contributing to a 529 plan is usually going to be protected as well.
What about some people put UC1 filings on their properties or record a mechanics lien on their property? So they have your property's worth $1 million. You have a $500,000 mortgage on it, and then you put $1 million contractor lien on your property and let it just sit there.
So if you are putting legitimate liens on your property, that's a fine strategy. If somebody wants to loan you some money, they can get a lien in your house. You put that money into an offshore account. That's a fine strategy. But putting fake liens on property could be considered wire fraud and cause much bigger issues.
So it can get stripped. It doesn't really offer any protection.
If it's a fake lien, correct. If it's a legitimate lien,
like paper trail, you can show the paper trail of actually getting money for it.
Right, but if you're recording liens and not actually moving money, that's problematic.
That'll do more harm than actually good.
Exactly.
Because there's a lot of gurus online. They're saying, "Oh, it's easy. You just have your mortgage and record a fake lien, and that protects you."
When I started in the industry over 10 years ago, I was very interested in that strategy, but I did not set it up because I did my research.
Yeah.
But it's not a strategy that I recommend.
How easy is it to strip that?
How easy is it to break it apart?
Yeah.
Well, it's a bluff. And so lots of times a bluff will work. It's not going to hold up in court, but simply having property that's harder to find that's in your name, that's helpful. I don't like to rely on bluffing, planning, but aside from it potentially being illegal, a bluff is fine.
I remember at early on in my career when we had a lot of asset protection attorneys come and discuss the topic, and one of them was family partnerships, creating family partnerships and putting your assets in a family partnership. Any input on that as far as like which one's more effective or how that works versus the...
Sure. So the first thing to understand is family partnerships can be structured just like limited liability companies, and limited liability companies can be structured like family partnerships. I think the main reason that partnerships are still being pushed by attorneys is because we can get away with charging more for them than we can with an LLC. People are more comfortable going online and register an LLC. If you can make it complex, you can charge more. Again, not the style of planning that my firm does.
Some attorneys charge $50,000 for that. I mean, it's not a cheap way of setting it up.
Correct. And there are certain times where a high fee is justified, certainly if you have multiple partners who are in matters within the partnership agreement are being negotiated. But for a simple holding company, for a stock account or a simple piece of real estate, I believe you can accomplish the same thing with an LLC. Now, what you get with a limited partnership or a multi-member LLC or a single-member LLC in some jurisdictions is what's referred to as charging order protection. And what the law says is that nobody can reach into your company and take money out of it. All they can do is put a lien on it. So let's say that there's a asset worth $1 million. Somebody has a $500,000 charging order. They don't get to take out the revenue each year. However, when the value of that business grows, they're still responsible for the taxes. So it becomes a huge disincentive. Now, the problem with that is the same problem I have with a domestic trust. Any U.S. entity can be disregarded by a U.S. court. And if the defendant is a unsympathetic plaintiff, or we have a judge who's just very result-oriented, they would disregard that structure. And it puts you in a much weaker place to negotiate if you don't have the safety of an offshore account.
What state out of all 50 states would you consider like the safest state for the investors or or whoever has the assets? Which states offer the most amount of protection, and which states have the least amount of protection?
Okay, so if we're talking about
just general,
if we're talking about setting up a domestic asset protection trust, Nevada is the state that we would use.
The safest?
They have the least exemptions to reasons a creditor can pierce an asset protection trust.
Got it. So if you own property, let's say in California, you could create your holding company in Nevada and then have your subsidiaries in California. Is that so?
You can live in any state and create an LLC in any state, or live in any state and create a trust registered in one of about 18 different states, which allow for the use of a domestic asset protection trust. However, I don't advocate for the use of domestic asset protection trust because Article 4, Section 3 of the U.S. Constitution says that every state must give full faith and credit to the judgments and court orders of every other state. So if you have a Nevada asset protection trust, but California has issued a judgment, the asset is still held in California, I'm going to bet most of the time the creditor is still going to be able to get that asset.
Got it. And then why is it some companies are always incorporate in Delaware?
So this is a very interesting question. Some people think it's because they have the lowest taxes, but then another state could just copy that and lower the taxes. The reason that Delaware is a common jurisdiction for incorporation is that it has a good system by which the laws are enforced. I heard the example of back when the internet came out, a lot of laws were changing and different states were having trouble adapting. Delaware was doing a very good job of adapting and adjusting and keeping things predictable and consistent in the outcomes of how businesses should be handled.
With what happened with Elon Musk's compensation package in Delaware, do you think that's changing? That Delaware is not really the safest place to incorporate now?
What happened with Elon Musk?
Well, they undid it. The judge in Delaware said, well, his comp package is too high. We're just going to undo it. And so now he wants to move his, I guess, the headquarters from Delaware to Texas now because of that.
I think it is a sign that United States is increasingly becoming a less safe for wealthy people to keep their money. You don't want to have a situation where people with money are fleeing your jurisdiction. This seems to be a lot of what's going on in Europe. This seems to be a lot of what's going on now with some people in other states I'm not going to mention.
Sure. What do you think about the Cook's Island? What if that jurisdiction changes, or what happens if you set all this up and then all of a sudden someone else comes in office and go, you know what, we want to cooperate with the U.S. or we want to cooperate with creditors now. What do you guys do in that scenario for the clients that are already set up there?
So we have the flexibility to move every single trust, as I mentioned, through the use of a trust protector. And it's the reason that I'm out traveling so much, so that we have backups and other options in other jurisdictions. We've got trust companies that we work with in other parts of the world, and we can just easily move the trust from one location to another. Now, that being said, let's look at the Cook Islands. They've been in the asset protection industry longer than anyone else. It is a very safe country in terms of doing business and simply walking around there. I go and visit every single year. You could sleep out on the beach and you'd be fine. It is a place where every single individual knows that at some point they will own land. What issue with a society is when you've got a large group of the young population that doesn't feel like they have an interest in the system. Like, I don't know, United States, where lots of people of the younger generation are not able to, may never be able to own a home. In the Cook Islands, every single one there has an interest in continuing to.
So there's stability there.
Keep the system going. There's stability there. And they love this industry. It doesn't cause any harm. It doesn't cause them to have to give up any resources. It doesn't mean there's a lot of tourists coming through. It is an industry that they are very well interested in protecting. It's a vital part of their economy.
And it's a good, revenue generation for their economy.
Very much so.
Got it. So you feel like for the long term, that Cook Island is probably the best bet right now for the highest amount of security you can pretty much get.
It's the reason that we focus on the Cook Islands. I think Nevis is a very good place for an asset protection trust as well, and Belize is one that I consider as well. All three have great laws in place. Stability is better in the Cook Islands and Nevis than Belize, but all three of those jurisdictions I consider to be very good, safe jurisdictions that will welcome Americans.
Interesting. That's really interesting. I've looked and I've seen online a lot of Cook Islands, or like for anonymity and for a lot of these things. Does that also provide anonymity?
It does, as much as any offshore structure does. The reality is the world we live in today, one through the internet and the ability of people to research, but also simply through a court's power to order you to disclose your assets. Everything that we set up, we are well aware can be brought into court. That being said, simple disclosure of the asset does not in any way compromise protection.
Interesting. Very interesting. I love this topic because
we haven't even gotten to the other side, which is the Swiss banking side.
Back in the day, it was like from 80s and 90s movies that you watch, Swiss banking was, they don't even know what your name is. It's just numbers and zeros. They'll give you a bunch of numbers, and that's your account number, that's your account name. They don't need to know anything else, and a password.
What a time to be alive.
Yeah. So what is it now?
So that's not how it works anymore.
Okay.
There is a common misconception that Swiss banks will not take money from Americans. Back when Obama was president, beginning of the Great Recession, a lot of Swiss banks were getting in trouble for not reporting funds to the U.S. government. Now, they were not doing anything illegal under Swiss law, but it was illegal under the United States law. And there was an agreement that if you are going to take money from somebody who holds a U.S. passport, you have to report it to the IRS. And a lot of the Swiss banks said, we are not going to comply with this, and we're done taking Americans. A lot of other Swiss banks said, well, we are bankers, and we love money.
UBS.
And Americans have a lot of money, And we're actually going to change our business model to cater to the American market. And there's definitely lots of Swiss banks which will gladly open up bank and brokerage account, can hold crypto there, can hold gold and silver in Switzerland. In terms of account size, you're looking at usually around $1 million between your bank and brokerage account. Minimum. In some cases, we can get accounts open for as low as 500,000.
And can you keep currency in US, or it does have to be Swiss franc?
US dollar, Swiss franc, euro, other currencies.
What's the interest rate? What are the interest these accounts are paying for keeping assets there?
It depends on which currency you hold. It depends on how much risk you want to take on. If you want to,
well, local currency is going to have probably high inflation and high interest.
Well, I would say Switzerland doesn't have particularly high
theirs is not
inflation.
Yeah. But in general, like I know some countries in the Middle East, for example, have high inflation. So if you keep currency in their local currency, you'll get like 25, 30%.
Correct. You get high
but then your money is devaluating when you convert it.
You've got options with lots of different currencies you can invest in. If the client's assets are below 500,000, we can open an account for them in Cook Islands for as little as 250 or Panama for as little as 100,000.
Does that also get you a green card, passport? I mean, not a green card, but passports?
No. Little trivia about the Cook Islands. You cannot get a passport to the Cook Islands unless your mother or father is a Cook Islander. You will never become a Cook Islander.
And how easy is it to travel to the Cook Islands with a U.S. passport?
It's easy in terms of you can get in.
Okay.
It's hard in terms of getting there. Right after COVID, there was only flights from Auckland and Sydney. They did open up some flights through Honolulu, but it's tough to get to, which is great because it makes it harder for someone to.
Yeah, it's more expensive.
Exactly.
But generally speaking, my understanding of asset protection is you got to make it so expensive. Like, for example, if you're worth $10 million, it costs $20 million to pierce it and collect it. So no one does it. It's more of a deterrent by making it more expensive. To set up the process you're talking about, how much does it cost to break through that? Or actually, like, if someone really wants to come at you, how much will it cost to attack it, pierce it?
Well, it's rare that anybody tries too hard because even if they do, chances are once you get to court, you're going to lose. So what we can do is disincentivize somebody from even starting. Generally, they don't find out about the trust until after they've already gone through the entire lawsuit in the United States. And maybe they spent a few $100,000 to bring the case, or maybe they took it on a contingency fee. If they took it on a contingency fee, there's a good chance they don't have any money to go litigate overseas. If they've already spent hundreds of thousands of dollars, well, at least we've eaten up some of the plaintiff's resources.
But that means you're spending hundreds of thousands defending yourself too, right?
It means that you are spending a bit to defend yourself as well in all likelihood.
So how do you prevent that?
So how do you prevent that? Well, then you try to settle earlier. So if the trust has been set up and is aged properly, 1 to 2 years, though you get a lot of protection right away. But if it's at a point that we're comfortable showing our cards, then you show them at the very beginning. And what will happen is some plaintiff will go out and sue 7 different defendants. 6 of them will be stuck in the lawsuit for years. 1 of them will settle within 90 days because they have a trust.
Got it. So just depending on where you're at strength-wise, you want to either play the card or not play the card and let them just bleed out.
Correct. And then if they try to go to the Cook Islands, they're going to have to post a bond. What's popular about Nevis is they have a codified $100,000 bond. I was speaking with the premier down there a few months ago, encouraging him to raise it from there. It's been at $100,000 for a while. Cook Islands does not have a codified bond requirement. It's in the discretion of the judge, but it can be $100,000 or more. So
do you also have to go and defend yourself in the Cook Islands?
So the trustee will either have an attorney that defends or will hire an attorney that defends the case in the Cook Islands. It's very hard to win a case in the Cook Islands. You have to prove your case by a standard of beyond a reasonable doubt. In the United States, that's only for criminal matters.
Yeah, it's preponderance. Typically,
here. It's a preponderance of the evidence. 51%, 49% you win. You have to win it by 99%. You cannot amend a claim. So if you started a lawsuit in the Cook Islands and realize you need to change something about the initial complaint, you have to start over at that point. Statute of limitations is probably run.
Got it.
On top of that,
what are the legal fees over there to defend you in that scenario? Let's say you got someone with big pockets that just wants to bleed you dry. They don't care about winning, but they just want to bleed you dry. And so they go over there and sue you, and you got to hire an attorney in the Cook Islands to defend you.
It's similar to what a United States attorney would maybe a little bit less, but similar to what a United States attorney would charge on an hourly basis. If they start doing that, you also have the ability to move the location of the trustee from the Cook Islands to Belize and make them post another bond and make them move their case to another jurisdiction. And sooner or later, the plaintiff is going to realize if they ever want to get paid, they need to talk settlement.
Got it. And so does your firm handle that process as well in the defense in the event of one of your clients gets sued? Do they also help with the defense as well?
So we don't serve as defense counsel, but we will work in conjunction with defense counsel to help them utilize the trust
to the fullest,
to the fullest to get the best possible settlement.
Got it. That's good. So it's like the dart and you guys are the poison for the dart.
I like to think so. Yes, exactly.
Okay.
We're the ayahuasca for the sickness.
I mean, have you done ayahuasca?
Hypothetically,
I mean, we're in Mexico.
Hypothetically, 6 months ago, I went down to Reunion, Costa Rica, and it was an amazing experience. It got me to the point where I got focused on work. I felt my heart open like never before. It was not fun. You have to.
Yeah, it's painful.
It was painful, but I'm not afraid of pain. And it was great and absolutely life-changing.
Mine was 10 years ago, my hypothetical situation. 10 years ago in Peru, in the hypothetical jungles of Peru. And again, it was, if I would have done it then, it would have probably been similar to what you're saying.
Yeah.
Unbelievable experience, I would assume.
I think people should go out and have experiences. Now, make sure that you are with a professional, because it's like driving a car. It can take you places, but it also can get you hurt if you're not properly guided.
Yeah.
Just like setting up an offshore trust, it's all about the proper guidance.
What would you say the first step would be to reach out to you guys? Like what documentation do you guys really need to know? What information you need from a client before they reach out to you?
So when the clients reach out, we're going to ask about their net worth, qualify them to make sure that it's worth our time to work together, to make sure it's worth their money to set up the trust. Understand their risk profile. Is there any pending litigation that they're concerned about? And then get a grasp of how their assets are allocated. Once we have that information, we may make a recommendation for setting up a trust. Once the clients hire us, we then need some background information on the client just to verify that they're not involved in any money laundering. They don't have any drug dealing in their background, any issues related to theft of money. Now, the trustee doesn't want to be protecting dirty money. Now, if you have something in your background like a DUI or a pot charge or something unrelated to stealing money or accumulating wealth, then the trustee is generally not going to have any issue with that. Once we have the proper information, the client will also sign the trust document. We'll send this off to our colleagues in the Cook Islands. They'll sign it off as well. We'll send it off to our colleagues in Belize or Anguilla as the trust protector. And then the trust will be registered with the Cook Islands. Next, the trustee would then open a bank account, most likely in Switzerland. The first process we say takes about 30 days. If clients are being very responsive, we can expedite it. And then it takes another about 4 to 6 weeks to get a Swiss bank account opened. Once the account is open, the clients will wire their funds in. They can transfer them over in kind. They don't have to realize any gains at the time they move their brokerage account over. And then they can sleep well at night. They'll still be able to.
What if it's real estate? What do you do with the real estate?
So if it's not the primary home, it should be an LLC first or some other type of corporate entity, and then have that owned by the trust. And we want to get that done as soon as possible. Next, we will tell the clients to consider doing some equity stripping, which is mortgaging or selling the property. But if they want to wait to sell the property or mortgage it, they can. The most important thing is to have it under the umbrella of the trust as soon as possible. That way, you have the flexibility to take further protective measures down the road.
When you assign the beneficial interest of the entity to the trust from yourself individually, does that usually trigger a higher reassessment of taxes?
So it transfers in or out of the trust are not a taxable event. In terms of reassessing taxes, generally no, because the beneficial owner has not changed.
Because it's still technically your trust. You're
Correct.
The beneficial interest of the trust.
Correct. You're the
So
beneficial
the intermediary is just basically being placed in.
Correct.
And then, so you got the beneficial interest covered. And as far as let's see, so the beneficial interest changes, the taxes don't get reassessed. I forgot my train of thought.
Okay.
We're getting into a complex area. Of
how about crypto? Can we put crypto into the trust? Yes, we can. We can put crypto into the trust, and there's a few different options for how to do it. One is to set it up with a bank that we work with in Europe. They could hold the crypto. Another option is to utilize a third-party vault, or the clients can self-custody the crypto, provided there is no pending litigation. So you set up the trust, you assign the crypto to the trustee turns around, hires you as a custodian. In the event of litigation, the trustee might fire you and hire a different custodian. But this gives clients a lot of peace of mind and time to get comfortable with the foreign trustee and the structure and still hold their keys in the meantime.
Do you think real estate owners would be able to use this more, or like crypto guys? Well, who do you think can benefit more from this?
Crypto guys, stocks, bonds, cash, these all get very good protection. These are very very protectable assets. Real estate can and should go into the trust. Even if you hold it domestically, it still makes it harder for someone to take away because a court can't order you to hand over the asset. You can report in a financial affidavit that the value of that real estate is $0. And if they want to go after the asset, they have to start a separate foreclosure action. So it is still beneficial to own real estate, and it gives you the ability to, if you decide to, take further measures and equity strip the property. So yes, real estate's a very common asset and a very good, important one to protect as well.
Equity stripping generally when you're getting financing is like 70%. You can't really go more. How do you protect the other 30%?
So a couple of options. There are some lenders that we have relationships with that will loan up to about 95% of the property, or you can find a hard money lender who may bridge that gap, or you can simply accept that they may come after that portion. And if they do, offer them a settlement. So let's say it's a $100,000 property. There's $70,000 of mortgage on the property. There's $30,000. The cost for foreclosure right there is going to be probably $15,000, $20,000. You can just simply say, instead of you spending all that time on foreclosure, why don't we just give you $10,000, $15,000? And if you were being sued for $100,000, to walk away paying $15,000 to keep the property sounds appetizing.
Got it. You said there's some hard money lenders, but the rates are usually 10, 12%. That might kill your rate of return on that investment.
That may eat into it, and that's something you have to weigh against the risk of losing the asset.
Got it. One recommendation I had was in that scenario where you have your first mortgage and you're stripping the equity by getting financing, is taking that money and then rolling that money into an investment, but then you have the actual cash that you have to worry about protecting. But then you can put it in the trust.
The cash into the offshore account. Yeah. You can buy a CD with it, and that CD could pay the monthly interest rate.
Yeah, yeah, interesting. Yeah, I've seen it, read about it. Was never got a chance to sit with someone that actually talks it, because you see a lot of attorneys online, and they're like, "Well, we'll do this for you, or we'll talk about it." But then I'm like, I don't know where you're located. I don't know if you're in China. I don't know if you're like all over the world and you're just selling me a fake bill of goods that I'm going to fill this out, and then it's going to be a tax nightmare. I'm going to get audited, and then it offers no protection. But
it does not increase your chance of your audit if it's done properly. It offers the most protection. I'm based in Miami Beach, Florida. We have offices in Denver, New York, and Dubai as well. You can look all of us up online, BlakeHarrisLaw.com.
It's great actually having you in person. Here, in person. Yeah, you do exist. You're not AI. You're not.
And there are some people in the industry who will try to hide behind a website and not reveal their name or their face. And that's not my style. I think the foundation of the trust business is trust.
Interesting. Brian, you've been super quiet.
This is so up your alley.
Why? Just because I do commercial real estate?
Yes. And PE and all the other fun stuff.
Yeah. Interesting. What about for private equity? As far as like investments in private equity, would you recommend putting those deals in trust as well?
Certainly. To the point that you can register the PE funds offshore as well, that helps even more. But
just a little risk is because you got capital from investors in the hands of a foreign trustee.
Oh, so I was thinking your individual private equity.
Oh, individual deals. Yeah, you could do that too.
Yeah, yes. Your investment in a private equity.
Yeah.
Now, if the private equity fund wants to set up its own offshore trust, it can do that. Typically, if they're sitting a lot of cash, it makes sense to do that. If it's a company that's not sitting a lot of cash, they're always looking for another deal to push into. There's really not a lot of benefit to it. But if it's a private equity fund that wants to hold some money offshore and you've got investor money, the investors should be excited about it, that their team is taking action to keep the money protected, and it's going to be held by a Cook Islands trust. And then the money's going to be in a Swiss bank account, which is probably going to be much safer than whatever U.S. bank.
Will it also offer protection against labor laws, in the event, like, let's say you own a company through a fund and the company is getting sued because of labor laws or whatever?
So employment litigation is one of the most common issues, one of the most common lawsuits, one of the fastest growing areas of the law. Mm-hmm. In terms of protecting the business from the employment lawsuit, it's kind of hard to have the business avoid getting sued, but what you can do instead is have the business thinly capitalized so that there's nothing to take, and then everything you pulled out of the business, holding that in an offshore account. So if the business has hard assets, sell those and go lease the assets. The business has cash pulled out of the business, and then when there's nothing left for someone to take from a business, then it becomes less likely someone's going to sue, or they will be more willing to settle.
Well, I got all my questions answered.
Anything we missed, Blake?
So the Swiss banks, just want to talk about them for one more moment, which is I talk about them being safer. The American banks will often have about 5 to 10% of their cash on hand. Swiss banks will often have anywhere from 25 to 40% of their cash on hand. On top of that, the banks that we work with, they're mid-sized banks which don't have any U.S. presence, and they will not engage in any investment banking. They don't engage in any prop trading. They don't even let outside investors who pressure management to take risky bets.
I think the thought of a bank going under, especially like the ones that are too big to fail in the U.S., is we know the government's always going to bail them out now, except for the smaller ones. If you're too small, yeah, you could fold and Chase will buy you out, or some of the big boys will buy you out. But
correct.
For the most part, the Federal Reserve is pretty quick to like bail out the ones that are too big to fail.
That seems to be the history. But
then they can pull the rug too.
But if you're looking to invest internationally, there are very safe banking options as well.
Would you name one or two of the top banks that
I will not be able to do that, because if I do that, they will no longer work with my firm.
Oh, okay.
We're very careful about when we share the names of the banks in Switzerland. As a client, we will open you up to our Rolodex, but the banks will terminate relationships if we name them on camera. So they just like their privacy, and we will adjust to the customs of the local people we work with.
Okay, fair enough. So UBS is not one of them. All right.
Well, this has certainly been fun. The final takeaway, the final asset protection tip, the biggest mistake that people make is waiting too long. An ounce of prevention is worth a pound of the cure, and that is never more true than in the asset protection field. If litigation has already started, there's often something we can do to mitigate damage, but you will be in a much better position, and you will have much better peace of mind in the meantime by pre-planning.
Thank you. And where do people find you?
Blake Harris Law. That's BlakeHarrisLaw.com. That's social media, Blake Harris Law, Instagram, TikTok, YouTube, Facebook, X, all the major platforms, Blake Harris Law. Fill out a contact form on our website, and somebody will reach out to you shortly to discuss protecting your wealth. And if you're interested in learning more in addition to social media, send me an email, Blake@BlakeHarrisLaw.com. Happy to share a copy of my latest book on asset protection.
Great. Do you have a promo code you like to leave with our guests for maybe like 10% off if they use our name, Truth?
If they use the name Truth. So
how much of a discount are you willing to give the clients, the
listeners?
That's you like how I put you on the spot there with a discount.
Well, when I get asked for a discount, my usual response is the question is, can you do anything about the price? My response is, yes, I can charge 10% extra.
Okay.
Or if someone says, can I get a discount? And then if they ask again, my response is, if you ask a third time, I'm actually going to raise the price on you. We already give our clients a very good value. If they mention Truth Hurts podcast, then I will say nice things about Brian. I'll say nice things about you. But beyond that, no, we're not giving any promo.
So you bring up a very good point. And the point that I'll leave with is this. In commercial real estate or real estate in general, when you ask for a discount from your broker that you're looking to sell a property, and if they fold right away and give the discount, you should be very careful of working with that person, because if they can't defend their own fee and their own income, then how are they going to defend the value of the property that they're representing for you? So it's a very good, important point that you bring up, that, you know, if you're working very hard to defend your fee, gives me more confidence knowing that if you're working that hard to defend your fee, then you're doing a better job.
We've already
defending the clients.
Negotiated very substantial discounts with our offshore providers for our clients, given our firm's level of experience in this area. And I have been told by the CEO of the top Cook Islands trust company that for the past several years, my law firm has registered more trust with them than any other law firm in the world. We've never once lost a penny for a client. There's definitely cheaper options. There's definitely attorneys who charge a lot more. We give all of our clients a very good value, but we're not spending time negotiating.
Great. Don't use the promo code TRUTH, because it's not going to work. Thanks, Blake.
Appreciate you, Blake.